I'm completely at a loss. I'm completely in the dark.
Welcome back to my channel, The Public Record. I'm Andrew. Major General Feroz Khan was expected before the Madlanga Commission, but after the shooting in Houghton, Khan was not in the witness chair. Instead, his legal team stood before the commission, and what followed was not just a postponement. It became a public test of Khan's secret hearing bid. His side said Khan was sedated, not verbal, unable to give instructions, and facing a mountain of material: WhatsApps, bank statements, financial records, and sensitive intelligence concerns. But Madlanga's question was simple: what exactly must be confidential? And after that application was pulled, the hearing turned into a second battle. Media remarks, possible leak implications, hospital access claims, and an unreserved apology. So today, we follow the full record. Not rumors, not conclusions, the record. The first question was simple: why was Khan not testifying? His advocate told the commission that Khan was unconscious, sedated, and that his legal team had not been able to get proper instructions from him. They also referred to a redacted J88 medical report. And because there were already rumors around the shooting, Khan's side invited the commission to satisfy itself about his condition in hospital. This matters because the legal team's whole position depends on instructions. If Khan cannot speak, he cannot assist his lawyers. If he cannot give instructions, they cannot easily repair affidavits. And if he cannot commission a supplementary affidavit, then the application itself becomes difficult to fix.
All right. Subject to the proviso that despite what is floating around in the media and doesn't bother us too much, that General Khan is actually unconscious, sedated, and we haven't been able to get access to him for purposes of further instructions in relation to this. So obviously the supplementary affidavit will arrive as and when we are able to present it.
Any further submissions? I just want to ask a quick question.
Yeah, there was an invitation for us to present medical evidence. We have now received the J88, which we will immediately make available to our colleagues. And there is a request.
Please continue.
There is a request by the family members.
Yes, Mr. Khan.
Yeah, it's a redacted J88. There is a request by the family members that I invite, given what is being said in the media and in the social media, and the concerns raised by the police, there's allegations that this is a contrived shooting, etc., and that General Khan is in fact lying relaxed in hospital eating jelly, that we invite the commission, the chairperson and or the further commissioners to have access to him in hospital and to speak to his medical attendants and verify and satisfy yourself that he is in fact in an extremely critical situation as set out in the J88.
So Khan's side was not presenting this as a small delay. They were saying, our client is not able to testify, not able to give instructions, and not able to help us fix this application today. But the commission still had an application in front of it, and that is where the pressure started. Now we get to the legal issue. Khan had brought an application for parts of his evidence to be heard in camera, in plain English, behind closed doors, away from the public, away from the media. Khan's side was not saying everything must be secret. They accepted that not everything should be in camera, but they argued that some parts may involve intelligence, confidentiality, security, and possible IDAC-related issues. On the surface, that sounds serious. Khan is linked to crime intelligence, so yes, some information may genuinely need protection. But the commission's problem was this: the application did not clearly say what must be private and why.
Mr. Khan, what is the first issue that you say is now disposed of after you read from the answering affidavit?
That is our General Khan's application for an in-camera hearing, which was delivered on Sunday before the unfortunate incident. So the evidence leaders yesterday delivered an opposing affidavit, but it is a qualified opposing affidavit where they concede that there are potentially certain matters that may be sensitive and requiring considerations of in-camera application. But they, however, raise certain points in relation to the terms of reference and specifically what should be in camera as opposed to a blanket in-camera application. So, reading from what they say in their opposing affidavit, we accept the invitation that we better formulate what it is exactly that we want in camera, because we have made the concession that not everything ought to be in camera. There are other considerations emanating from this as well, which we've communicated to them, and we don't need to detain you with, but there might be a need for IDAC to comment on certain things that we wish to say. So it's a work in progress at this stage.
That phrase is important, a work in progress, because Madlanga was not dealing with the future application. He was dealing with the application already filed. And once the commission looked at that application, the question became very direct. Madlanga's first problem was the lack of detail. He wanted to know whether Khan was saying only the Houghton bust could be heard publicly and everything else must be behind closed doors. Khan's advocate said no. So Madlanga asked the obvious follow-up. Then what else may be heard publicly? That is the key. A commission cannot close the door simply because a witness uses words like intelligence or security. There must be a proper basis.
But nothing stops us from dismissing the application outright on the basis, for example, of vagueness. And I must tell you outright that I feel that the application is very vague. For example, I have no idea altogether whether what General Khan is asking for is only for evidence relating to the Houghton bust to be aired publicly. So I don't know whether that is what he's saying. All that can be heard publicly is Houghton and nothing more. If that is the case, the affidavit does not explain why everything else is out of bounds in terms of being aired publicly. There's nothing there altogether. For example, let's take what is contained, just one example, the communications between General Khan and Mr. Sayed. Let me not get into the detail of what those say. You know what they say, and they are out there in the public domain. But the point is, looking at those, at face value, those appear to be private communications between Mr. Sayed and General Khan, without an explanation as to why those raise security or intelligence issues or confidential issues. I'm completely at a loss. I'm completely in the dark.
That is the first real crack in the application. The commission is not saying sensitive intelligence can never be protected. It is saying, show us exactly what needs protection. Do not ask the public to leave the room without a proper reason. Then Khan's side brings in the size of the record. They say that as late as last week, they received something like 370,000 line items of WhatsApp messages. They raise questions about authenticity. Were messages altered? Was the chain of custody retained? They say they asked for supervised access to devices, and that access had not been given. Then they put the calculation on the record. If they spent 10 seconds reading each WhatsApp message, it would take about 200 days. And then comes the next number, 11,000 pages of bank statements. From Khan's side, the point is clear. How can we properly prepare, answer, narrow the application, or advise the client when there is this much material and when the client cannot give instructions?
Part of the context is that as late as last week, we received something like 370,000 line items of WhatsApp messages.
Yes.
The evidence leaders in their affidavit seem to intimate, well, it's your WhatsApp messages, you should know about it. There are considerations such as the authenticity of the messages, whether they are altered, we don't know. Whether the chain of command has been retained, we don't know. We've invited access, and these are all the events before Sunday night. We've invited supervised access to the devices. That has not been forthcoming. So we have considerations, and my attorney's done a calculation. surprisingly, that if we were to spend 10 seconds reading each WhatsApp message, it'll take us about 200 days to get through all of them. So in that light, we ask for the indulgence that we have the opportunity, and the evidence leaders have, for all intents and purposes, acknowledged this, that we be given the opportunity in the fullness of time to better formulate this application and to allow us the opportunity to place full information before the Commission. Suffice to say, as late as this weekend, we received another 11,000 pages of bank statements with the explanation that, well, it's your bank statement, you should know what's in it. We, of course, need to go through this, and because we are now hamstrung, there is an amount of delay. We asked the Commission, and correctly so you have pointed out, that you are not bound by what the evidence leaders say. We ask you for that indulgence. Given the extraordinary circumstances that we are faced with presently, we hope to be able to move matters forward and to better present ourselves before you. And it's simply an indulgence at this point in time.
That is a strong argument for time, but it is not automatically a strong argument for secrecy. And that is exactly where Madlanga takes it. Madlanga separates two things. 1. Lateness. 2. Confidentiality. The document volume may explain why Khan's team says they need more time, but it does not explain what in the application is confidential, what relates to state security, and what must be heard behind closed doors. That is the heart of the legal dispute. Khan's side is saying, look at the mountain of material. Madlanga is saying, that still does not answer my question.
If I understood the application correctly, you raise those issues in the context of seeking condonation for the lateness of the application. That has nothing to do with the question that I asked, which is, what is confidential or relates to state security, relates to intelligence? What is it in the application? You have detailed all of the things that you have detailed, and none of that addresses the question that I put to you. I hope you understand. Also, and of importance is that even if you complain about this material that you say was delivered late, General Khan, through your assistance, I assume, has brought an application for an in-camera hearing, stating, as a matter of fact, it doesn't say there's a whole lot of material or stuff that's still outstanding. He has come to this commission asking for an in-camera hearing on the basis of state security, confidentiality, intelligence matters, investigative ways by the intelligence operatives, all of which should not be aired publicly. So he took himself or understood himself to have facts to come to this commission that has nothing to do with the material you have just placed before us. Because if that was the issue, then he would not have been ready to bring the application. So my point about the application being vague stands.
Madlanga then gives an example. He refers to communications between General Khan and Mr. Saeed. At face value, those may be private communications, but private does not automatically mean intelligence. Private does not automatically mean state security. Private does not automatically mean the public must be excluded. Before the commission closes the door, it wants the basis.
For example, the application in so many words refers to the relationship between General Khan and Mr. Saeed, and I think it's the only example it actually touches on. I may be wrong. So it does refer to that, and all it does is to talk about context and how the intelligence system bears relevance to that relationship. But are we to take General Khan on his word on that? We cannot. We cannot grant the application on his word. There's some context. What context? There's some bearing. What bearing? We are completely in the dark. We cannot grant an application like that. So it's on that basis that I say, why did General Khan come before us? At that stage, he was well. He had not been shot.
That is a serious point. The Commission is not saying Khan is wrong about everything. It is saying the application must stand on evidence and explanation, not on broad claims. Then Madlanga goes even further.
That there has now been an offer which General Khan, through you, is grabbing is something else altogether. Was there an application before us in the first place? If there was, on what basis was it brought before us?
So,
because I mean, I have said it's vague. I could actually go further and say it's hopeless. From where I'm sitting, it's hopeless.
At this point, the issue is not only Khan's medical condition. The issue is whether the application itself was strong enough when it was filed. Khan's side asked for leeway. They do not want the application dismissed immediately. They say there is no replying affidavit yet. They say Khan cannot currently give instructions. They ask for room to come back with a better version. But the Commission's procedural answer is important. There is already an application before them, not a draft, not a discussion, an application. So the Commission says Khan's side cannot keep it floating in the air until some unknown future date. Either argue it as it stands or remove it and come back with a properly motivated application.
But more importantly for me, it is we either now have an application for an in-camera hearing or we don't. You have an option. You argue your case on the application that you have filed, and you've had the discussion with the chairperson about it. But that is the application that we have in front of us. You either argue that or you withdraw it. You cannot have a holding position, because listening to you effectively are asking for this in-camera application to be held in abeyance. So you have a holding position. We don't get to decide, the chair doesn't get to decide, give a ruling on this application, but it's held in abeyance until an unknown time, when you eventually will come back and say, now I'm ready to supplement or to file a replying affidavit. But that cannot be. I think you have only two options. You either argue this application and say, we've made out a case. And on the, because I'm not going to speak to you about you can make a case in the replying affidavit. I think you fairly conceded to the chairperson that as a matter of procedure or process, you can't do that. So you have pleaded a case in the founding affidavit. It's either good or bad. You stand or fall by it. Your alternative is you withdraw that application and refile a new application whenever you do that. And matters and the prevailing position on the second option would be we don't have an in-camera application until you file a new application. It's that, and yeah, I think you can respond to that if you want. But it seems to me that's the position that must prevail.
That is the turning point. The Commission is not saying Khan can never bring an in-camera application. It is saying this application, as it stands, cannot just remain unfinished while the Commission waits. Eventually, after taking instruction, Khan's advocate asked for the application to be removed from the roll. That is the first major outcome. Khan has not testified. The in-camera bid has not succeeded as filed. And if Khan's side wants parts of the evidence heard privately later, the message is clear. Bring a proper, focused, motivated application, specific reasons, specific topics, specific protection.
The mic is, yeah. So that's where you find yourself. And I, speaking for myself, I understand your difficulty because you are counsel. You don't have the authority to withdraw or to tender a withdrawal. You would need to take instructions. But it seems to me that the proper thing would be for you to say the application should be removed from your role today, and your attorneys will decide what to do with it. They may very well, give a notice of withdrawal. But you seem to be understanding Commissioner Baloyi's position, because none of what she says prevents General Khan from bringing the same application properly motivated. Because even your notice of motion, your prayer too, as it stands, I have serious difficulties with it. So it's not a simple case of just supplementing or filing a replying affidavit. You need to fix your notice of motion as well. So it makes sense to me that the application has to be withdrawn. And if you are so instructed, you file a proper, motivated application that deals with the issues that you want to be heard in camera. Because as it stands, those are not there. It's just blanket statements that, we do not understand. So with that in mind, maybe without wasting any further time, just tell us what you want to do, and Chair will consider that and we will move forward.
Thank you, Commissioner. I've heard you say that without giving legal advice, a prudent course might be to simply remove the application. And I'll ask that we remove the application from your roll.
Thank you very much. The removal is yours. It's not done by us. So I assume that we must take the application as removed.
Thank you very much.
All right.
But the hearing did not end there. After the application issue, Madlanga turned to a second matter: statements made in the media after Khan was shot. The commission had decided not to answer those remarks through a media statement. Instead, Madlanga raised them in open session, on the record. The first issue was timing. When were the papers served? When was Khan shot? And if public remarks suggested a connection between the filing of papers and the shooting, the timeline mattered.
Here's my difficulty. You suggest in the interview, you mentioned the unfortunate death. Obviously, even though you don't mention the name, it's obviously a reference to witness D or Mr. Marius van der Merwe. You say a witness that testified at the commission has passed on. And you then mention the fact that the application was served. And then you suggest that there is or must be a leak within the commission. Everything looked at in context, you are suggesting that General Khan may well have been shot as a result of that leak. Because if you're not suggesting that, why else mention this? Am I interpreting your response correctly?
So General Khan had in recent weeks expressed concern about his security, both to myself in preparing for the matter as well as his attorney, Mr. Valley.
This part must be handled carefully. The commission is not saying Khan's lawyer intended to accuse the commission of causing the shooting, and Khan's lawyer says that was not his intention. But Madlanga's concern is how a reasonable listener could understand the remarks. In the context of Khan being shot, in the context of papers being served, and in the context of possible leaks or compromise. Madlanga says those words could be understood as pointing suspicion toward the commission. Khan's advocate denies that this was what he meant. But Madlanga's point is bigger. When you speak publicly, intention is not the only thing that matters. How people hear it also matters.
So understood that to go back to the context in which General Khan was shot. So all of that, when you look at it holistically, it suggests that we served the commission late last night. He gets shot after service of the documents, and there are leaks within the commission. When you look at the totality of all that, it does suggest, or it may reasonably suggest to a reasonable listener, that you are basically saying that as a result of the leak, General Khan, or rather, General Khan may well have been shot as a result of the leak from the commission. That would, or that's a possible way in which a reasonable listener would have understood what you said.
May I reply?
Yes.
I unqualifiedly before you and the media say that that is not my instructions, and that is most certainly not what I intended to communicate to the media with my attorney and family members of General Khan present.
Thank you. May I say this then? If you are ever to make media briefings again, be careful of what you say and don't say anything that may tend to impugn the integrity of this commission. You should be very careful about that.
I note what you said.
Are you within what's colloquially referred to as the organized bar, or are you a so-called independent?
Organized bar.
Organized bar. Well, as I know them, having been a member of the so-called organized bar for many, many years, there was, I'm not saying there should still be, because even within the bar sometimes there may be disagreement, but there was a rule that said members of the bar can only go out to the media, be interviewed and make statements to the media after having received permission from their bar. Otherwise, you don't just go out there and make. I repeat, I'm not saying that that rule should still continue to exist. Perhaps some might even say, does that not infringe the right to freedom of expression and so on and so on? But the point I make is, if that rule still exists and without it having been removed from the rules of the so-called organized bar, I wonder whether you got the permission, or if you didn't, what your basis for engaging in this in the first place was. But anyway, that's not for me. I'm just stating that that's how, as someone who once was a practitioner, that's how I know the rules to have been. I don't know if they still are. Anyway, you have said that that was not your intention, and I've already admonished you never ever to make statements that may tend to impugn the integrity of the commission.
Then the commission turned to another part of the media interview. Khan's side had said they understood that people were directed to go to the hospital to confirm Khan's condition. Madlanga says that is serious, because if people went to the hospital claiming to be from the commission, that is one thing, but saying the commission directed them is very different. Madlanga says clearly he gave no such directive, and he says the commission would not send police to a hospital to check on a witness. Khan's side explains that the hospital situation was chaotic. Different people, different police units, different claims of authority. But the commission's concern remains. If the information was unclear, why say it publicly in a way that could point back at the commission?
Thank you. I'm Mohammed Veli. I'm General Khan's attorney of record in this and other proceedings.
Yes, thank you. I must tell you outright that there is no way that I or the commission would ever send police to go check on anybody who, say, is in hospital. That just cannot happen. And I would imagine that anybody applying their minds closely and carefully should realize that we would never do that as a commission.
Madlanga then becomes blunt. He says the information placed before the commission is nebulous, unclear, not properly verified, and he asks how this could be said publicly for all of South Africa to hear. That is the heart of the second fight. This is not only about the hospital. It is about legal representatives speaking publicly while facts are still moving. One sentence can become a headline. One impression can become public belief. And in a matter like this, the commission is saying, do not speculate. Do not suggest more than you can prove. And do not implicate the commission without a verified basis. Khan's advocate then apologizes unreservedly.
You see, the meaning you want to convey would apply to this or make sense if this was what you had said, and we understand that there were people who claimed to be representatives of the commission, because I understand you to be making the point that I've just made. That is not what you said.
I respect
That is definitely not what you said.
I respect and accept your correction of what I intended to say. Certainly, I intended to say exactly what you've said at this
But
moment.
unfortunately, you did not.
Unfortunately, I did not.
You conveyed something negative about the commission.
In the moment on live TV, with my attorney next to me, with multiple interviewers, it is unfortunate. And if there is any misapprehension or ambiguity,
let me not accept that there is. Let me just say you stated something wrong about the commission. If you want to say misapprehension, it must come from you, but you stated something wrong about the commission. Yes.
Unreservedly, I apologize to the commission.
Then, the evidence leaders put their position on the record. Advocate Hassim's point is sharp. When asked about speculation, the answer should have been simple. I will not speculate. Full stop. Nothing more. The evidence leaders say the media remarks created concern because they seem to link the filing of papers with the shooting. And the message is clear. Put the facts on the record. Do not run the commission process through media impressions.
The leak, the point of the leak. The answer, the prudent response would have been, I will not speculate, full stop.
I said I was going to come to the timing. I forgot, but let me leave it now. I think we've debated it, and Mr. Khan has tendered an unreserved apology, I think, in respect of both issues that I raised with you.
I confirm that.
Thank you. Please continue, Ms. Hassim.
Thank you, Chair. All I'm saying is that the answer, the appropriate answer would have been, I will not speculate. Full stop. Nothing further. But instead, the comment went on to suggest a link between the filing of papers on the commission and the terrible incident that followed. Or, in fact, it didn't follow, according to the timeline.
Then the evidence leaders deal with the document issue. Khan's side had spoken about massive volumes of material. WhatsApps, bank statements, financial records, thousands of pages. But the evidence leaders say the picture is not that simple. They say some of the material had already been provided earlier. They say the weekend version was in a more usable format. They also say the new financial material was relevant because they intended to ask Khan about financial disclosures, bank information, companies, inflows, outflows, and his financial position. So here we have two competing frames. Khan's side says, we were flooded with material and need time. The evidence leaders say, much of it was already provided or made more usable, and the new financial material was relevant to what they planned to ask.
And that is incorrect, and it can't be allowed to stand. It is true that there was a volume of material that was provided to General Khan on the weekend. That information was the same information. First of all, it was information that it included information that had been provided to General Khan at the time of the answering affidavit in the urgent application, which was around the end of the first week of June. One set of chats, which was the chat between General Khan and Mo Sayed. And then it included all of the information that had been provided on 15th June, what my learned friend complained about, these spreadsheets, the WhatsApp communications, these lengthy lines of communications in the spreadsheets. That was provided to my learned friend on the 15th of June. What was provided on the weekend was a more usable format of exactly the same information, an easier to read format of the information, and in fact, a truncated version of that information, because by then we had curtailed exactly what it is we wish to refer to when we were going to be questioning General Khan.
Now we get to the forward-looking part. Even though Khan is not there, the evidence leaders still want to proceed. They identify broad areas they want to put before the commission. Material from the answering affidavit, additional evidence they say is relevant, and evidence relating to Khan's financial position, wealth, and lifestyle. The important point is procedure. Can evidence be led while Khan is absent? Advocate Hassim says yes. She says it is not without precedent. Evidence can be led, and if Khan later becomes available, he can respond. That means the Khan story is not frozen. the Commission may still place evidence on the record, and Khan may still get the chance to answer later.
Ms. Hassim, I thought it was not so much the content, but the procedure. How do you intend to proceed on Friday in the absence of General Khan? So if you can just address that.
Sure. Well, thank you.
Not so
Commissioner
much
Kumar.
the content
So
of...
it's not without precedent. We would follow the same kind of approach that was followed when a previous witness, Mr. Van Beek, was unable to be present. And the evidence is led, and that does not mean that the witness, in this case General Khan, wouldn't have an opportunity to respond. In due course, he would have an opportunity to respond.
So in summary, the evidence leaders intend to present that evidence to the Commission, and if General Khan at any point should come back, he can respond to that.
That is correct.
So what did today actually give us? First, Khan did not testify. His legal team says he is unconscious, sedated, not verbal, and unable to give instructions. Second, the secret hearing bid did not proceed as filed. The Commission pushed one question again and again: what exactly must be confidential? Third, the document numbers are important: the WhatsApp line items, the 200-day reading estimate, the bank statements, the financial material. But the Commission's point was clear. A document mountain may explain delay. It does not automatically justify a closed hearing. Fourth, the media issue became a serious warning. Madlanga made it clear that public statements must not impugn the integrity of the Commission, and Khan's side apologized unreservedly. Fifth, the Commission may still move forward. The evidence leaders say evidence can be led, and Khan can respond later if he becomes available. So today was not Khan's evidence. It was the battle before Khan's evidence. So the record today is clear. Khan has not testified. The secret hearing bid did not proceed as filed, and the Commission may still hear evidence before Khan is able to answer. This is the public record. I'm Andrew. I'll see you in the next one.